You know, it's never too early to start thinking about your will. So has the idea that you should write a will actually crossed your mind, but you don't even know where to start? Well, we have the person for you. Joining us now is attorney Kamisha Mickey, the founding member of Mickey Law Group. Hello, Houston. Kamisha, how are you?
I am fabulous. How are you, Frank?
I'm good. So let's get started.
Yes. What is the difference between a will and estate planning?
A will, people think of on more simple terms. I am writing down what I want to happen to my assets when I die.
Okay.
Estate planning, you have a lot of assets, mostly real property, maybe trust, things like that. So you need a bit more instructions than just the will alone.
So should everyone have a will, or does it have less of an impact for people maybe with a certain monetary amount?
Everybody should have a will.
And what should the will have in it?
Yeah.
If you feel like you don't have any money, why do you need a will, and what should it say?
And I think that's a really big misconception.
Yeah.
So many people think, oh, that's for rich people or other people, not me. But really, why should people have a will? And like Frank said, what should be in it?
Because number one, sometimes you have assets you've potentially forgotten about. Mm-hmm. The things that you do have, your personal property, where's that going to go? Who's going to get that? And also, if you inherit something, now where's that going to go? Because there are various rules according to, like, okay, what if we're in an accident together? Like it's either me or my parents or me and my siblings. And now based on the intestate rules, if you don't have a will, who's going to get what?
And intestate means you don't have a will.
Don't have a will. You just,
That's right.
That's never good.
We're speaking with Kamisha Mickey, an attorney and founding member of the Mickey Law Group. You can join the conversations with questions for Kamisha at 713-440-8870. We have a call from Gary from Waller. Gary, welcome to Hello Houston. What is your question for Kamisha?
Well, I have a last will and testament and a power of attorney that were set up by my sister-in-law, my last living relative after my wife passed away, but she lives in Florida. And these documents require witnesses and a notary. And I haven't been able to get down to a notary, and I'm wondering, is it mandatory if there are no contesters and no other living inheritors or relatives to contend or forge my signature, basically? Is the notary mandatory for something like that?
Well, thank you. Under normal circumstances, yes, you need a notary. And that's normally because they want to ensure it is you who actually wrote or, had the will made and it is going according to your wishes. However, I would suggest that maybe call a mobile notary. Have someone come to you. And that way kind of takes care of the problem. You don't have to go anywhere. And then you fit all the requirements so that there are no unforeseen problems if something were to happen.
Yeah, I've heard, you could just write your will out on a yellow legal pad.
Or on a
back of
napkin.
Envelope. Yeah,
or
right.
napkin.
Yes.
Have you heard of that?
You can do that. It's a holographic will.
Yeah.
Really?
Do you have to have it notarized?
You do not. The only issues that kind of come up sometimes when you write your own, if someone wants to contest it, is now we have to prove it's your handwriting.
So let me ask you this. When Celeste leaves me everything, do I also unwillingly get her bills?
You will have
and
to.
debt.
You will
That's what
have
I
to take
mean,
care
yeah.
of that.
Feels right.
I will.
You will have to take care of that.
Well, I don't want anything from you. In that case.
Oh, good thing I don't have it.
It depends on what she left, but yes, the debts and liabilities need to be taken care of out of the estate.
So everybody's like, oh, I'm in the will, but maybe you don't want to be in the will.
That's right. So in the state of Texas, do people need, and you kind of touched on this in regards when we were talking about the napkin, but do people need a lawyer for a will to be an actual legal document?
No, you do not have to have a lawyer. You can write your own will. There are various things you can find online and still have them valid and legal. They give you the process to have the two witnesses and the notary. However, I, of course, suggest people speak to a lawyer because there are various ways you can distribute your assets that may be better than other ways.
So what happens if somebody doesn't speak to a lawyer? They don't realize that their assets or the money that they do have, whether it's a lot or a little bit, what happens when they pass away and where does that go?
People fight.
That's why we have you here today.
Yes, people fight. If you don't tell people what to do with your assets, the state of Texas will decide what to do with your assets.
So that's probate court.
Probate court, Texas Estates Code, it tells the succession, who should get what. if you have siblings, parents, children, husband, wife, all of those things. So if you don't give instructions, the state of Texas will happily distribute your assets according to their own rules.
So then what happens if you have multiple wives and lots of children?
People fight.
And it just stays in probate. I mean, basically, who gets to decide
You
that
could be
then?
lost in probate for many years if something like that were to occur. So if a parent, you die, you don't have a will. If you have your husband and you just have children with your husband, of course, community property goes to your husband. Personal assets can be distributed, between your husband and your children. However, if you have a husband plus an ex-husband, and your ex-husband, you have children with him, and then you have children with your new husband, that's a whole other can of worms.
Yeah,
Yikes.
sure it is.
But what happens when a family member is the executor? So parents, they have a will. They say, okay, we've spoken to a lawyer. Now I'm going to make this person the executor of my will. And let's say they're estranged from the family. So they're estranged from their siblings. The parents pass away. Can they get around from having to inherit those family members?
If you are an executor, that means there is a will in existence, and you've been named the person to take care of distributing the assets from the estate. Mm-hmm. You will have to distribute things according to what it says in the will. So whatever your parents said, hey, I want this sibling to get this, whether you hate their guts, you never want to speak to them again, you have to ensure that that person gets those things. If not, then that sibling can approach the court and explain to them, hey, here's the valid will. I was supposed to get this. They did not give me this.
What if nobody has the will?
Oh, if no one has the will, then it's almost like you died intestate without a will. And then the state of Texas is going to tell you how to distribute your assets.
So from a legal standpoint, if parents make a will, should all siblings that are going to inherit from that family get the will?
Get a copy.
Get a copy of the will.
They can, but you can leave a copy with your attorney. You can leave a copy with a friend. Just anyone you want to have a copy can have a copy. I don't suggest leaving tons of copies because then when you make changes, if you forget to tell someone.
So let me ask you
Pass it
this.
out.
So, okay, I make my will today, and Kevin and I make our will, all right? And I go to an attorney up in Brenham, and I say, you know what? I want to make a different will. Is it and we're not going to tell Kevin. we're gonna leave everything to Celeste.
Yes.
Yeah.
Sounds like a great idea.
This kind of thing happens,
And it does.
People have mistresses and they want them in the will, but they don't want to tell their wife that they're putting their mistress in the will or something.
Dios mío.
And so this is July or June 13th. So I go in on June 15th and make this new will. Does that take precedence over the old will?
If you acknowledge in the new will, there's a standard line they use. This takes the place of any previous will, that I created. Yes, the new will on the 15th will take the place of that will.
So someone could proffer, once you die, a different will and say, sorry, this date is after that date. This is the new will. You're cut out. I'm in.
Absolutely.
How do you prevent that from happening? If you're the heir, if you're the wife, how do you make sure your husband doesn't go do that?
You cannot.
That's why you need a good lawyer.
That's why you need a good lawyer. You cannot prevent. No one has to leave you anything. Parents do not have to leave. In the state of Texas, parents do not have to will their children anything. As a wife or a husband, you get half of community property. But personal property or anything separate property, they can give it to whoever they wish.
Community property, 401ks and pensions and what you have in the bank, or just your house?
Your house, anything that accumulated during the marriage.
Okay.
Including money.
Including money, unless it was inherited from of your grandparents. Oh, I'm going to give you this in my will. That's separate property, even while married.
You're listening to Hello Houston. We are speaking with Kamisha Mickey, an attorney and founding member of the Mickey Law Group. You can join the conversation at 713-440-8870. Now, how important is it when it comes to life decisions to put that in your will? Is that something that goes there?
No, there are different documents that you can include. What we typically do is there's the last will and testament. There's also, I know the caller mentioned, a power of attorney. We have a medical power of attorney and a durable power of attorney. The durable power of attorney is for making decisions for property, things, financial decisions, things of that nature. A medical power of attorney is if I am incapacitated, this person should make decisions for me.
And what if I said if I'm incapacitated, Kevin should make that, and we both become incapacitated? Should you have a backup or how?
Yes, in those documents you are allowed to put, this is the first choice, second, third, fourth.
Okay.
So we do about 3 or 4 for instances like that, just in case.
Yeah.
So what do you think people should know when they are actually thinking about, they're on the fence? Do I need it? Do I not need it? I know we've established everybody should think about it. But truly, what if somebody says, I rent, I don't have, I lease my car. Do they still need a will?
I wouldn't, in that instance, if I rent, I don't have a home, I don't have a car, I don't have any high valued assets, I know they'll hate to hear me say this, but I would potentially tell like a friend or a sister, like, if something happens to me, just take this stuff.
Take my stuff.
Just take this stuff.
Could
or
they
give it to my
write-
sister, or, they'll handle it.
Could somebody say, write it down on a
Yes.
piece of paper. If when I pass, I want this family member to go through my apartment and
Yes.
collect my car.
Yes, and some apartments are even doing that now on applications and whatnot, or once you're moving in on your lease, if something were to happen, who should we call to take care of that? Because that happened in my building once.
We did have an off-air
Really?
comment. If there are no contenders, I think you answered this. If there are no contenders for your property in your will, why would the notary be mandatory? Did you say it was mandatory or suggested?
That's interesting.
It suggested, and only because if there are no contesters, great, wonderful, you may not have a problem. But you really don't know if there are contesters until there are contesters.
Right. So better safe than sorry.
Yes.
We have a call from Amy in downtown Houston. Amy, welcome to Hello Houston. What's your question for Kamisha Mickey?
Yes. My question is, a will that was done in 2010, the father deceased in 2016. We never did go to probate court or anything or filed anything. We're presently living and taking care of everything, his assets of what he left in the will for us. And I was wondering, how is the will still valid, being that it was just notarized?
Wills are valid as long as they, follow what the Texas Estates Code says, how you have to prepare them, which is, it's notarized and you have the witnesses. It's a valid will. Now, whether you have to go to probate or not is the question. If no one's fighting and everything's, been distributed, if you're not having a problem, I don't see why you would be forced to do that. That mainly comes up if there's property, you need to change deeds and things of that nature, then yes, at least file it with the court. It doesn't cost a lot, and it just lets the court know, hey, this is what's happening. This is the valid will. In case someone does something untoward later, they can go back and say, this is what the courts ordered us to do, and these were the instructions from this valid will that we held.
All right. Thank you, Amy. We have another call.
Emmanuel from Texas City with another question about a will for Kamisha. Welcome to Hello Houston, Emmanuel.
Hi. My question is, if a family member, let's just say 2 siblings, get left a will, and one of them, the older brother, tricks the younger brother into signing over a piece of land that was left by their parents to him. And the younger sibling's wife goes and tells them, hey, you can't do that. You're siblings. You're supposed to share that money. Is there a way that the younger brother can go back to court and get that money, that piece of land, half of the piece of land back from the older brother? Or is it too late because he already signed off on the paperwork saying that, oh, my brother can have it?
So make sure I understand. Both siblings are currently living, but one somehow got the younger sibling to sign over his inheritance,
Correct.
basically.
Correct.
Okay. You can go back. I think there's a statute of limitations on how long you can go back. But in order to do that, you would most likely need to prove fraud or duress. It can't be, I just changed my mind and I don't want him to have the land anymore. You've got to prove to the court of how he tricked you out of this land.
Yeah, fair enough. Let's take another question. This
Thanks,
is
Emmanuel.
Hillary. Yeah, I always have something in writing, that's for sure. Hillary from the Woodlands, what's your question for Kamisha?
Yes, so I have 2 children. My husband and I both have $1 million policies for life insurance. I am an organ donor, and I also signed up for Donate Life. I'm wondering if my husband and I both pass away, is the donate life enough, or do I need to put in place like a self-directive or a medical power of attorney? Because what I signed up for, I think they just take the body, and then if there are remains left, then my children might get them. And then I just, with the policies, if they're both under 18 and my husband is no longer with us, then who would take care of the money for them?
Okay, two-part question. First part, as far as the children and your policies, if something happened to you and your husband and your children are under the age of 18, if you do not have an appointed guardian, the courts may appoint them a guardian to take care of that money until they reach the age of majority, until they reach the age of 18. And as far as the donate life, yes, that policy should be fine, what you've signed with them, but it never hurts to have a medical directive just in case.
You know, along those lines, there's Maurice from North Houston who has a question on living wills. Maurice, are you there?
Yes, I am.
What's your question for Kamisha?
I just got my will ratified and witnessed by two, it's all legalized and so on like this. Do I need an additional living will?
It's not necessary, but as part of, I feel what a good will package would be, I always get a living will, which is basically a medical directive. A medical power of attorney just basically says, hey, if something happens to me and I'm incapacitated, quickly, this person makes the decisions. But a medical directive is basically, if something were to happen to me and I'm only being kept alive by artificial means, I do not want that. Do not do that to me. So it's like a decision you made, and the person you name in your medical power of attorney would have to follow those instructions.
Well, and hospitals, if you have to go in for an operation, they're going to ask you if you have that.
Yes.
And they're going to want you to have it.
Yeah.
And if you don't, you're going to have to go through some red tape. So I would get at least that. Mm-hmm. This is an interesting text that we got. My father-in-law recently passed away, left nothing but lots and lots of debt. Specifically, the business he was a co-owner of owed the IRS quite a large sum. He did not have a will, so does my mother-in-law, his wife, inherit all of his debt?
For a business, no one person would inherit the debt. The business inherits the debt, which means they will take whatever assets the business has, sell whatever needs to be sold to pay whatever can be paid after that. But no, the wife or the children will not inherit the debt.
But
what about personal? Sorry.
Right, I was going to say, so what if this small business owner was taking out equity from his home to help fund the business? Now, does that mean that the bank would then come after the home that the wife now lives in?
Normally, the surviving spouse has a life estate. They try not to take homesteads in most any debt issue. But if your house was used as collateral for any type of debt, yeah, secondary to if there's another lien holder, there's a mortgage on it, yes, they have every right to take the home for whatever they're owed.
What's the most complicated situation you've seen, without getting too in the weeds?
Most complicated situations happen when they have property, real property. You've got multiple houses or land somewhere. You have stepchildren, children with the current husband, like I said, and children with previous, spouse, and you've left no will, and your heirs don't get along.
Conway Twitty.
Yes, because now it's everybody's fighting because of what I want, but you got to follow whatever the state of Texas says, which could be, like I said, you're tied up for years.
It seems, I'm old enough to have been in a few of these situations. So it seems the best thing people can do, too, is to put everyone's name on the house. Make sure that if you want your kids to have your house, their name is on the deed. And then it passes to them when you both die. Same thing with checking accounts and 401ks or whatever. Just make sure if your name is on it, you're golden.
Yes, for 401ks, insurance policies, things in banks, bank accounts, things of that nature, they have their own documents already in place. You already named like a bank account with a person who has the right of survivorship. So it's the two names are on the account. If one survives the other gets all the things.
You're listening to Hello Houston. We're speaking with Kamisha Mickey, an attorney and founding member of Mickey Law Group. You can join the conversation at 713-44 850-8870. We did get a YouTube comment that says, approximately how much should I expect to pay for a will to be done professionally?
Not what you would charge, because we don't want to say that, but give us a
In
range.
general, about how much does that
depending
cost?
on how many documents you want, if you just want the will alone, but or you have the will, the medical directive, medical power of attorney, all those things. So you can find anywhere that would be from, as low as some online services like $500 up to a few $1,000s. Mm-hmm. And a lot of times it is dependent on what are your assets. If we're not having to make a lot of preparation and plans for assets, like how are we going to transfer this property when you die, who are we going to give this to, then it's a relatively, somewhat simple
The
matter.
simpler, the cheaper.
direct.
Yes.
Andrew says, what if your siblings are in Texas, but your parents live in a different state?
They can do the will according to the laws of their state, but they can name the children here for whatever they want to give them.
Got another call from Peter from here in Houston. Peter, what's your question for Kamisha?
Yes, hi. So I have a scenario where my parents just own one house and they only have a 401k. So I wanted to know, would they need a living will or trust, or is there something that's more simple than that? And that's all the assets that they have.
Well, for the 401k?
401k.
Yeah. For the 401k, they're going to name a beneficiary through the 401k. And whoever they name, that's who they will give that money to. That will does not control the 401ks, life insurance policies, and things of that nature when they already have a beneficiary named. As far as the home, if it's their homestead, it's their only home, whether it's paid off or not, I would try to make plans or preparations, get a will, and take care of that, because there are different ways you can transfer, like I said, real property, which is a home, land, or what have you. You have a transfer on death deed, which means, we drafted this deed, it's to be filed, and they take care of it after after the person dies, or in a couple of other ways. So definitely try to take care of the real property.
And we did get another YouTube question that says, can you file a copy of your will with the county?
You can.
Do you recommend it?
It's not necessary, but if you think something may happen, then I would recommend it.
I will say this, and we got to wrap up here. I don't think we've had as many calls from one person, so thank you for being here. When I finally did my will, it was in the year 2000, so I was 40 before I ever got to it. Because it's like, well, I'm not going to die. That's what people think.
He's very young,
This
Frank.
means I'm going to die. But you know what? After I did it, I felt so cathartic. Like, if something does happen, the people I love are taken care of.
Thank you, Frank.
Yeah, it's true, Celeste. And then I redid my will with Kamisha, so you're out of it.
There you go. I'm out of it. I'm getting cut of
Kamisha
it.
Mickey
And
is an attorney.
I do think we have one more call.
Another
real
call we're
quick.
going to take?
Do we have another call on the line waiting for Kamisha?
Okay, let's see. Yeah, Gayatri from the Energy Corridor.
Yes.
Gayatri, what's your question?
Yes. We both are alive, and we have executed a will, survivorship document, and COD, in addition to living will and so forth. Would that be adequate?
It sounds like it should. I think you have all the documents. As long, I would leave a copy of them with someone that you trust, and make it known that you have a will, because a lot of times that's, people try to pretend, oh, I didn't know they had a will, or they don't have one. So make sure people know that you have this. And
the big misconception in life is the reading of the will.
Yes.
People don't read. This is not Agatha Christie. You have a
of the
will. There's no
will.
big reading of the will. And I would say, tell people what your plan is before you die, so that there won't be as much fighting.
Yes.
And people already know.
yes,
If you have the
that
guts.
helps.
Kamisha Mickey is an attorney and the founding member of Mickey Law Group. Kamisha, thank you so much for being here.
Thank you so much for having me.
Thank you.
After the